Mr. Liner, come to the microphone. So the matter now before the court is the State of Tennessee versus Charlton Liner, case number 25 CR 096 and 25 CR 231. I want to state for the record, the matter is scheduled for attorney status today. When I reviewed this file yesterday, July 31st, I saw that Matthew Rogers has filed a pleading into the file, and I'm going to read it to you. I don't know if you are aware of it. It says, "Come now, Matthew C. Rogers of Rogers Law, PLLC. Respectfully provides notice to the court that neither he nor the Rogers Law, PLLC has been formally retained in this matter pursuant to the contractual agreement made with Mr. Liner. Although Mr. Liner has expressed his intent to proceed with said agreement and has clearly stated his desire for undersigned counsel to represent him in the above referenced case, he is currently unable to satisfy the financial terms of the agreement due to his lack of access to funds. Specifically, Mr. Liner's assets have been restricted as referenced in the order entered in Bradley County Circuit Court number V25056. While he possesses adequate funds to pay the agreed upon retainer, the current injunction prevents him from doing so at this time. Undersigned counsel is unavailable to appear for the attorney status hearing scheduled for August 1st and submits this notice as a courtesy to the court and Mr. Liner." So and I probably should look and see if that's filed in both of these files. The same notice appears in the second file. When we were last here, the state indicated to me that they had gone and reviewed a portion of the civil file, but there was a sealed court order that they were hoping the court would review. And so I did review the civil file, which is styled V25S056. It's Hopper et al. Versus Liner. The attorneys for the plaintiffs in that case are listed as Phil Jacobs, Rob Norred, Matthew Coleman, and Chandler McNabb. The attorney for Mr. Liner is Philip Lawrence. This lawsuit is a wrongful death action and an action seeking punitive damages. There was a motion filed to enjoin transfer of assets, and there were hearings held on this case in February of 25, which did result in certain ex parte orders being entered. There was a declaration by Matthew Rogers filed in that file as of February 6th of 25, where he swore under penalties of perjury that he is the attorney for the defendant. However, it was conditioned that said without payment of the retainer, he will not continue to represent the defendant. It occurs to me that here in August, that's what's happened. He's not received the money, and therefore he is not entering an appearance in the criminal action. There was a response filed to that motion where certain allegations were made as to the reasonableness or unreasonableness of attorney fees. There were orders that certain funds have been secured. There was a report from another defense attorney talking about what a typical defense of a first-degree homicide case should study. I did reveal a sealed order with specific permission of the court. And in that court order, the parties were ordered not to disclose amount paid to attorney for their retainers. But what I found very pertinent to the decision here is the judge appointed Brian Collins as your power of attorney, and the judge gave him access to a certain amount of money. I am not going to speak that onto the record because this is part of a sealed order. And in that order, Mr. Collins was ordered to reimburse himself for expenses related to his work as a power of attorney, to pay Mr. Lawrence, and to pay Mr. Rogers. And release of these funds were supposed to be reviewed every 90 days, and if necessary, they could even be brought back to Judge Sharp after 60 days. So my question is, have you not told Mr. Collins to pay Mr. Rogers?
Yes, at the time.
Yes, at the time?
I haven't spoken to him since then.
So, have you had, while you're in the jail, have you had contact with Mr. Collins?
Not about that. I haven't had any feedback. I didn't know that that hadn't been paid.
Because by my reading of the civil documents, you are not indigent. I cannot appoint counsel to represent you. I also conclude that Judge Sharp is very much aware of your need to retain counsel here. And so it seems that either you're instructing Mr. Collins not to cooperate so as to delay this proceeding, or Mr. Collins is being excommunicado with you and creating a greater problem for you.
That's what I haven't spoken with him, so I haven't informed him not to do anything like that, no.
Did you pick Mr. Collins as your power of attorney?
Yes, I did.
Did you sign a document giving him permission to manage your assets?
Yes, ma'am.
So does the state want me to schedule this for another hearing and issue a subpoena to Brian Collins as power of attorney for the defendant to bring him in here and see why counsel has not been retained? And whether it's Mr. Rogers or any other lawyer, if Mr. Collins is the one that's got charge of your money, Mr. Collins is going to have to pay whoever it is that you choose to represent. The thing I want to make patently clear to you is this new solicitation to commit first-degree murder is just on an attorney status basis. But this first-degree homicide, felony murder, and aggravated burglary has a trial date. Your trial date is set for May of 2026, and I am not going to let anybody's manipulation of the system, or for that matter, civil cases are not going to control the criminal court docket. And if you don't get a lawyer, be it Mr. Rogers or someone else, I'm not going to continue this court date. So I will not tolerate any delay or stalling tactics by anybody. So General, well, first of all, is there anything you want to say?
Judge, the state was going to request the same. We would also ask that this court order Matt Rogers and Philip Lawrence to appear so that we have everybody necessary to answer questions about finances and where they're going, because the state is also not wavering from the May 2026 trial date that has been set. Because as we stand here 116 days after arraignment on the first-degree murder, we have no attorney status, no attorney on the past two attorney statuses to even provide more information. And the state was able to confirm with the civil clerk's office that Brian Collins did receive and cash that check for the undisclosed amount. So that has been cashed, and we need to know what is going on so that there's no more delay in this matter.
Well, you know more current information than do I. So does the state want this on my very next date, August 18?
That
And
would work for the state judge.
are you requesting that a subpoena issue for these attorneys, Matthew Rogers, Philip, I want to catch that person's name again, Mr. Philip Lawrence? From the pleadings, it looks as though he's out of the Hamilton County Bar. And let's do the subpoena for Brian Collins, Deuces Tecum, his bank records for the power of attorney account so that we can see whether or not funds have been paid. All right, so that case will be scheduled for a hearing. So I'm resetting it for attorney status. My next date, 8/18/25, since we have lawyers and they have busy practices, do you want to schedule it for a specific time?
I would leave that to the discretion of the court, Your Honor.
I'm of a mind to have it first thing so that then they can get about their business. I guess it should either be first thing in the morning or first thing right after lunch.
The state will make itself available at any time that the court chooses.
All right. Let's do at 1 p.m. And then, as you hear from these people summoned, if you hear from them, I'm sure they'll express whether or not they're in trial somewhere or whatever. But so 3 subpoenas should issue. The state shall work with the clerk's office to make sure the power of attorney, the attorney in the civil case, and the prospective attorney on this criminal case have notice of that date and time. Mr. Liner, is there anything you want to say?
No, ma'am.
All right. So your next court date is August 18. And as you communicate with these people, reach out to Mr. Collins and tell him, pay your attorney, whoever it is you want to retain. And if we've got an attorney entering an appearance, perhaps this hearing will be abbreviated. All right, thank you.
I have just one more thing. I would ask that you just advise the defendant on his own right to request discovery. Should that be something he wishes to request and review as this attorney status is pending? The state will print out everything that can be printed out and provide any media on discs should he request that.
All right. I think that is a good thing. So right now our case is sort of stuck here until you get a lawyer. But there's going to come a time when if you're not going to hire a lawyer, then you're going to be your own attorney. And the Constitution guarantees you the right to represent yourself. If you self-represent, that's never a good idea because you're going up against lawyers who have been trained in the law, who have studied the rules of evidence, the rules of criminal procedure, and the court cannot help you. I am an independent referee, and so it puts you in a very poor position. But the state is right. If you feel as though you want to file your own motion for discovery, it's got to be in writing, filed in the court file, and the state has just indicated that they would honor that and release discovery to you so that you could begin reviewing it.
Okay.
All right, good. That's all for today.
Okay, thank you.